SJC-12670, Commonwealth v. Matthew Gumkowski.
Okay. We all here? Mr. Fellows?
I'm here.
Okay.
There we are. Well, good afternoon, Your Honors. Michael Fellows for Matthew Gumkowski. As you know from the brief, I've raised two larger issues, one of them broken down into many smaller pieces in this case. One is the motion judge's failure to suppress CSLI information from the defendant's phone records, or to suppress the phone records themselves, and the other involves jury instructions.
Mr. Fellows, let me jump to the CSLI issue first. We're dealing with the so-called repoll numbers, and you cite appropriately Augustine, all right? Did you consider former Chief Justice Gantz's concurrence in Augustine, where he distinguished between what he called telephone CSLI and registration CSLI?
Well, let me start by saying I received an email from ADA Nadeau just about an hour ago, conceding that that we're talking about CSLI in this case. We're not just talking about repoll numbers. So what we're talking about here is historical CSLI, which is tower information going back 24 hours. I have read Augustine, and I did read Justice Gantz's concurrence. Some of the technology he was ahead of in understanding from me, but I think I basically understood that he was talking about automatic cell phone information as opposed to information that happens when you actually dial a call. But the majority
one take on it is that what was distinguished in that concurrence, registration CSLI means it's when your phone registers to different points, and it leads to the GPS-like tracking. Telephone CSLI is what information is gleaned when someone picks up a phone and calls someone, correct?
Yes.
And then that was the same issue, jump ahead, in Collins, that talked about this repoll information in Collins. And the point that former Chief Justice Gantz made in the Augustine case is, just like when I have a landline and I call someone, that's a traditional telephone record, and I certainly am identified by my home address when I make that call. So too is telephone CSLI or repoll information, because you're not having the same tracking situation that you would have that makes it comparable to GPS. So how do you respond to that Gantz concurrence in Augustine as well as Collins?
Well, Collins, I'm not recollecting off the top of my head. I do. I believe the Commonwealth cited Almanar for repoll numbers. Repoll numbers and CSLI are not exactly the same thing. As the Commonwealth points out, repoll numbers, and in Almanar, that's what they talk about, can only show you where a person is within about 100 miles. This CSLI, although it happens less frequently than the automatic CSLI that Justice Gantz is talking about, can put you very close. And that's historical CSLI, is both
Very close. We have
held in Carpenter and in Augustine, and that is the CSLI we're talking about here.
Mr. Fellows, we have 3 miles. Is that GPS-like tracking 3 miles?
Yes. I mean, if you look at Carpenter, they talk about that they could put the location of the defendant between 4 and 11 miles of any place during this period of time, wherever he was. And it's not clear that they couldn't have gotten better than 3 miles. This was what Trooper Giossi testified to based on the charts that he had showing where the towers were. Now, they agreed, they stipulated that they wouldn't go further than 3 miles, but that doesn't mean that they couldn't have asked the the phone company to get more detailed, but they didn't.
Collins is the main case that Mr. Nadeau cites, and it's also the only case that deals with repole numbers. And you tell me you're not familiar with it?
I am familiar with it, but my point, as I wrote in my reply brief, is that these are not repole numbers. If you look at the phone records themselves, which is on page 47 and 48, I believe, of the record appendix, you know, the third to last column are repole numbers. And then the last two columns are first cell and last cell. And the description given.
I thought first cell and last cell are that's where the call starts and ends, right? So if I'm on my phone and I'm driving down to the Cape, and I'm talking for a long time, I could go from Hingham to Provincetown, right? But if I'm stationary, I'm going to be in Hingham the whole time, correct? That's what first cell and last cell means.
Yes, but it is CSLI. It is information coming from the phone that goes to the tower that's gathered by the company that can put you within a certain period of time. And as the court said in Augustine, and as the US Supreme Court said in Carpenter, it isn't just necessarily about what information you can glean from these specific numbers. It's they're putting in more towers all the time.
Right, but how is that different?
It's narrowing all the time so that the distance that you're going to be able to get from people is going to end up being in meters rather than miles. Very soon.
How is it different from
already.
a phone call from my house?
It allows them to follow you. And in fact, it allowed Trooper Giossi to show exactly where, assuming that Gumkowski was using his own phone, where he was when he was making calls during the 24-hour period. He put him in Attleboro. And this was part of him putting together his case, that he could put him within 3 miles of the crime scene, just from looking at a chart, and see that all of the calls that he made that day were in Attleboro. So that's tracking. And this court has said, you do that, you can do that, you can request 6 hours of that kind of information, historical CSLI. Anything more than that, you need a warrant and probable cause. And in this case, the Commonwealth has acknowledged there is no probable cause because they didn't even know who Gumkowski was when they sought these records. In fact, they sought records from 2 different phone numbers because this was an investigation. They were trying to find out who he was. So at the time they received these records, they had no information about him other than that there was a blonde person in the building who somebody thought their name was Matt. Well, that they took Kilroe's phone records, got phone records from 2 different people, or tried to get phone records from 2 different people who appeared to have called Kilroe at important times. And then they requested Gumkowski's phone records, and they specifically asked for CSLI.
Counsel, are you saying that unlike Augustine, the remedy here is not to go back to see if there was probable cause because the Commonwealth has conceded there is none?
Absolutely, yes. And there's no way they could show there is any because there isn't any. I mean, they're literally trying to find out who this person is. So they have no basis to believe that he has committed any crime at the time that they request the records. This is investigatory. This is why they need a warrant, or they need to find other information or request information that isn't protected. So but they asked for CSLI because they need CSLI because they're not just looking to find out who he is, they want to find out where he was, and they did.
Let me ask you a question about your second series of issues. With respect to the jury instructions, there was a recent case of Commonwealth versus Silva that dealt with the same judge, same type of instructions. You didn't address that. I'll give you a chance to address it here.
I don't know that I may have missed that case.
Okay.
Silva,
S-I-L-V-A. You would have an ER in it because of my brutal accent, but it's Silva.
Do you have a citation?
Yes, you can actually write us
I was going to suggest that.
It's 482 Mass 275, and it deals with the jury instructions, a hypothetical, similar inference hypothetical. So if you could address that in a letter, that'd be appreciated.
Okay.
Thank you.
Well, what I would say about the instructions in this case is that it isn't just the hypothetical that's the problem. The hypothetical may be the least of the problems in the jury instructions in this case. I think looking at the jury instructions in this case, it's important first to look at the posture of the case when the jury instructions were given. So the jury has two issues to decide. Has the government proven beyond a reasonable doubt their circumstantial case that Matthew Gumkowski killed Joseph Kilroe? And as part of that, they had to evaluate the credibility of Matthew Gumkowski. And another important piece to remember is that the Commonwealth in the closing argument had specifically told the jury that they should not believe Matthew Gumkowski on the stand when he testified that he left the room at 8:45. They should instead listen to or watch the interview he made with police when he appears to say that he was in the room between 8:45 and 9 o'clock.
Mr. Fellows, along those lines, when the judge says that you should be controlled by the video,
Yes.
is he saying that in the context of it's not what the lawyers say to you, it's all the evidence? Obviously, he can't say you can't consider other witnesses and anything that might conflict with the video or other statements. I thought that if you look at everything that he said, that what he was trying to get across, and it didn't come out well, I agree, was you're not controlled by what the lawyers say, you're controlled by the evidence.
Well, I don't think that's the context that a juror would take those instructions in, because he goes immediately from giving an instruction about expert witnesses, and then he says you're going to have a video. So he's not talking about, what the sources of evidence are right before he says this. He's talking about expert witnesses, and right before he talks about expert witnesses, he talks about the evaluation of evidence, and that's when he tells the jury, what do you do when you have an exhibit? You accept an exhibit. What do you do when that contradicts a witness? What do you use that for? A reason not to believe the witness. So that's the most sort of recent information they've had about what to do with an exhibit. And then he says, and it comes sort of out of nowhere, you're going to have a video, you're going to be able to watch it. Indeed, you should be controlled by it. And then at the end, a couple sentences later, he says, and if that contradicts, if your viewing contradicts anything the lawyers have said, you should pay attention to the video. To me, that comes as an afterthought, and would a juror who doesn't understand the law, only understands what they're being told by the judge, is going to hear that and say, I should be controlled by the video, including in the situation where it's contradicted by a lawyer. Now, the Commonwealth in their brief tries to connect it to his pre-closing argument instructions where he talks about this, but that's 80 pages before. The place where he talks about, when you take an exhibit and it contradicts a witness, you should use that as a reason not to believe the witness, is 2 pages before, or 3. So that's the more immediate context. And I think that the statement at the end, it doesn't say you shouldn't be controlled by this for any other reason. It says you should be controlled by this, including if the lawyer says something different from what you see on the video.
Well, we don't just look at it in isolation, though. I mean, quite frankly, this is a very experienced judge. He's not telling them that what evidence they can and can't rely on, and throughout the instructions, he's talking about them being the only judges of the facts of the case, and they determine the weight and value of the evidence. So we can't look at that misstatement in a vacuum, I guess.
I would ask you not to look at it in a vacuum. I would ask you to look at it in the context of all of the jury instructions regarding how the jury should deal with evidence. And I know this is a very experienced judge, but he made a bunch of mistakes and a bunch of erroneous instructions. He says, and bear this in mind, the defendant has a bias. Okay, that's not, you can consider whether the defendant might have an interest in the outcome of the case. Credibility is for you to determine. He says, bear this in mind, don't forget this, the defendant has a bias.
But did they just But does he follow up and say, and the police officers have a bias? Everybody has a bias.
He tries to fix that, but the police officers aren't testifying in their own defense. Gumkowski's only defense, his entire defense, is his own testimony.
Right. The proper instruction is that you can consider the defendant's bias as you would anybody else's bias, right?
Something like that. Yes.
Right.
These are
Here he
the
says
factors you can
has a
consider.
bias. Everybody's got a bias.
He doesn't say that. He says he has a bias. So, you know, and he in fact says,
You
you
can't
know,
just-
if
you
you
can't
have an
just-
exhip that contradicts a witness, you should use that as
you
a
can't
reason
just
not to
pluck
believe
things
the
out
witness.
of the context. You can't just say, well, he doesn't say that. He does say that police officers have a bias too. So we have to look at everything in context. We can't just take discrete sentences that you want us to.
No,
we're going to look at everything in context.
I'm not asking you to take anything out of context. In fact, as I say in my brief, I'm asking you to look at the instructions as a whole. Because if you do, you see that he ends up essentially arguing the government's case. If you listen to what he says the defendant has a bias. He does not tell the jury at any point that they have the same power with exhibits as they have with witnesses, that they can believe some, none, or all of it. So when he tells them, if you have an exhibit that contradicts a witness, what do you use that for? A reason to disbelieve the witness. He is privileging exhibit evidence over testimony. And he is telling them how specifically to use exhibit evidence. And this mirrors exactly what the Commonwealth has argued in their closing argument they should do. They should ignore the witness's testimony and accept the exhibit of his interview with the police. So it may be unintentional, but that's what he ends up doing. And then when he says you should be controlled by the video, again, you have to think about it, in my view, in terms of the average juror, not in terms of one of us. You know, the average juror knows nothing about the law. And when they are given instructions, they're expected to follow them. And so here, if they follow his instructions, they're left with no choice, it seems to me, but to accept the videotape and accept the government's argument. And this doesn't even begin to get into his series of fact findings that he requires them to make at the beginning of his analysis of evidence, that you have to find out who was in the room at the time, what each person was doing there, when each person arrived, what each person's purpose was in the room, and what each person did in the room, and what the sequence was of events was. Now, first of all, they don't need to find any of those facts. Those are not the facts they need to find. They need to find facts sufficient to determine whether the government has met its burden of proof of each element of the crime. That doesn't necessarily mean they have to find out who each person was in the room. But by expressing it this way, the judge ends up, if you think about it from a juror's perspective, it's like, okay, I have to put together this sequence of events. How do I do that? Well, I can look at two pieces of evidence. I can look at the Commonwealth's evidence, and I can look at Mr. Gumkowski's testimony. And if I look at the government's evidence, I can answer all of those questions. I have a very simple way to answer all of those questions. If I listen to Mr. Gumkowski's testimony, I don't, because he doesn't know why that person was there. He doesn't know what happened after the person left. He doesn't know who that person is. He doesn't know the entire sequence of events. But that instruction essentially puts a burden on him to prove that, because if he doesn't allow the jury to answer those questions based on his testimony, and the judge has told them, it's your job to find these facts. He tells them this twice, this sequence of facts that they have to find. If you have to find these facts, and that ends up putting a burden on him, because a jury is understandably going to say, well, we need to know the sequence of events, and his testimony doesn't tell us that, but the government's does. And I think it ends up lowering the government's burden of proof too, because it essentially says if he can't explain it, then their version is probably true, and you should accept that.
So
Combined with the other bad instructions, this leads the jury down a path to conviction. I apologize, Justice Lowy, you were going to ask me.
that's okay. I think you're almost out of time. I'll hold the question. Thank you.
Okay,
Anyone have
well,
Any further questions? Was there something you wanted to add, Attorney Fellows?
No, I think I would like to ask that you read my brief carefully and the jury instruction section carefully, and particularly the end part where I try to put it and
We'll
ask you.
read the entire brief carefully too.
I understand that, but it's to make the point that I'm not asking you to separate these things out. I'm asking you to look at them in combination, the way it's, the law says you should. That is what I want you to do. And if you do that, I think you will end up agreeing with me. Thank you very much.
Thank you. Attorney Nadeau.
Thank you, Madam Chief Justice. Good morning. May it please the court, or good afternoon, rather. I'm Steve Nadeau on behalf of the Commonwealth. I do note that I did send Attorney Fellows an email acknowledging that the cell phone evidence, or the 3-mile radius evidence in this case, does appear to be phone call CSLI. Although the motion judge here, her finding was that this was the repoll information that was consistent with Trooper Giosi's kind of generalized testimony. And then when this information came in by way of a stipulation at the defendant's second trial, that seemed consistent with, again, the sort of abbreviated testimony that went in. But I do note that in the defendant's first trial, I don't think this in front of Judge Garsh, I don't think this information came in by way of stipulation, and these keeper of records for Sprint did provide a much more detailed record of exactly what these records are. That's at volume 3 of the defendant's first trial, beginning at page 90.
So does Collins control or not?
I believe Collins does not control.
Okay. So what's your argument?
I'm sorry?
What's your argument then, if Collins doesn't control?
My argument would be, first and foremost, that where we are dealing here with, rather than a mandatory compelled disclosure under 2703 of the Stored Communications Act or the Massachusetts 27117B, whereas here we're dealing with 2702, which is a voluntary production of records in response to a request rather than a demand or compulsion.
Does that voluntariness make it not a search, given that the test of whether or not it's a search is the reasonable expectation of privacy as delineated in Augustine? I don't really understand the Commonwealth's argument here.
So I think the Commonwealth's argument on that point is relevant to a couple pieces.
So for example, my neighbor may have my house key, and the police come to my house and my neighbor says, here, I got a key, go on in. Not a search anymore because it was voluntarily admitted?
Well, even with a search into a home, obviously a protected zone of privacy, the most perhaps protected zone of privacy, the law does allow for distinction between consent entries, even where there's not actual authority, but only apparent authority to seek consent from a third party. And here there's a federal statute that provides authority to seek voluntary disclosure.
But even under the federal statute, under Augustine, there was the federal statute, and we said even under the federal statute, which is less than probable cause, it's not enough. It still falls under the Fourth Amendment. And so, and then Carpenter mimics that as well. So I don't understand this whole voluntary aspect.
Sure, well, Augustine, and I think almost all of the cases dealing with the Augustine issue involve Section 2703, a 2703D order, which is the mandatory. I'm sorry, blank. I think it's Chamberlain, which deals with the 2702, although explicitly the court notes they're not dealing with the constitutional issues there, but they acknowledge there's a distinction between the demand.
But you still need a warrant if there's a search. There's no third-party doctrine. So I'm with Justice Wendland. I'm completely perplexed, and I've read all this stuff. So, was there a reasonable expectation of privacy in this information?
Yes.
All right.
Because it appears to be his historical CSLI.
Okay. All right. So that's step one. Step two. What's the exception to the warrant requirement?
Well, here I think I would refer to Commonwealth versus Frederick, which doesn't appear in either of the parties' brief. I acknowledge that. The citation is 482 Mass 70.
Right. We know Frederick, so go on.
And there I would refer to the dissent by Justice Cipher, which raises the federal, good faith in requesting these at the time. This was 2011, about 3 years prior to the Augustine decision.
So you're basically saying that unless we adopt the good faith exception, the evidence was illegally obtained?
Well, no, I would argue that the fact that this was voluntary rather than a compulsion is a distinction that
It was voluntary. It was voluntary by the provider, not by the defendant, right? And we don't have a third-party doctrine in this area, right? So we have an independent expectation of privacy which belongs to the subscriber, correct? The voluntariness, as Justice Wendland say, if Justice Wendland said, "Yeah, go into my house," that's voluntary, not her neighbor. If Cell One back in the day or one of these providers says, "Sure, go ahead, look at Gaziano's cell records, I don't care," that doesn't mean anything because we have a third party. We didn't adopt that. So now we have, as you just conceded, and I was going off based on the assumption these are repo records, which I guess is conceded. So now we have something completely different. It's not briefed. So where does that put us?
And actually, in Frederick, that's one of Justice Lowy's concern. He has his own concurrence where the fact that it wasn't briefed was his own caution in not wanting to extend.
But I guess the problem is that you wrote a brief. I read your brief, and now you concede a major point an hour ago and now we don't know what your argument is, other than good faith exception. So you can't go, "It wasn't brief because we're here."
Right. And so I wish I had kind of caught up to this sooner, but as based on the motion judge's findings, the learning curve was steeper than I would have liked it to be, figuring out that these repoll numbers, or appreciating the real distinction between the repoll numbers, which the first trial makes clear the repoll number would cover an area, essentially Boston and the greater Boston area. And then this first and last cell information is what restricts it even further.
I guess we can decide about whether or not we want further briefing on this case based upon this concession. But does anybody else have any? Well, that's all the questions I have about this issue, because I don't know if we can go beyond this, but if anybody else has any questions, I don't know.
But just to clarify, it seems to me under Collins, the repoll numbers give you 100-mile radius. So you can say the defendant was in Washington, D.C. and not Boston, right?
Correct. That's my understanding.
That's about mobile switching centers. It's not about the information here, which is clearly CLSI.
And that is my understanding. But regardless of any good faith exception that has not been briefed, I would argue that the admission here, even if this CSLI information showing that the operative calls were made within 3 miles of some tower in Attleboro, the admission of that information was harmless. It did not lead, even as there are no fruits of that poisonous tree, because that 3-mile information did not lead to the apprehension or the identification of the defendant. The investigation centered on the defendant based on a request from the victim's cell phone records, and he was the only person they identified based on the numbers they requested from the victim's cell phone information.
Is this in your brief?
And I don't know if the harmlessness portion of it is.
Because I don't think it was. And so I thought that this issue was a make or break for the government. I thought that if this is not within repoll, that this is not harmless. But now you're suggesting an oral argument that this could possibly be harmless?
I believe it is harmless. And I don't know that I didn't go that far, because I thought this was controlled by Collins. And this just seemed to me repoll numbers, which took it outside the ambit of Augustine. And just based on that understanding, I thought we were sort of all on all fours here. And then obviously had to, when I realized my mistake, I had to sort of shift gears. But
Do you think,
But I would-
is the case controlled, or you're given up by the Augustine concurrence on the telephone CSLI versus registration CSLI?
well, I think my understanding of United States versus Carpenter is that the way, as they describe it, that distinction that the dissent in Augustine identified, I'm not sure, they sort of obviated the significance of that distinction. I think once, now we have the United States Supreme Court saying that the same kind of information is CSLI within the meaning subject to the warrant requirement under the United States Constitution. Whether or not the same is true under Article 14 seems sort of a moot point, if I'm understanding your question correctly, Your Honor.
Okay, I get it. And with respect to the jury instructions, I assume you're going to argue Silva.
Yes.
Okay. That's all the questions I have.
Okay, so it sounds like we may need additional briefing on this issue that's come up during oral argument. And what?
And I'm sorry, Your Honor, I'm obviously apologize for the way this sort of came in, and obviously willing to accommodate whatever the court would like to do. I'm prepared to sort of say my piece on it today, if that's what the court would like, or, handle this.
Well, did you?
If I may, Your Honor, I would frankly object to further briefing on issues that weren't raised in the Commonwealth's brief. The Commonwealth made a position, they made it clear this was not CSLI, and declined to argue anything else. And I don't think that they should be allowed to have a second bite at that apple. If there are things that are outside of that the court would like further briefing from, but otherwise, I'm sorry to interrupt, but I would have to object to that.
Okay, well, what I'm going to do is have, if the Commonwealth wants to say anything else about this particular issue, we'll hear you. If you want to submit something, I want to give the defense a chance to object to it, and we'll have to sort it all out afterwards. Are you all set, or do you have anything else to say, Mr. Nadeau?
Well, Your Honor, simply on just the CSLI, one last piece, I would just say that the defendant admitted in his interview that he was not just in Attleboro, but in the victim's room right before the murder. The defendant's neighbor places him in the defendant's room the morning of. Jodie Rose, his girlfriend, places him in near the park where she left him in Attleboro shortly after the murder, and there's blood on his shoes, blood on.
Didn't they find the defendant based on the information they got?
They found it on his records, but it's not, there's no indication that they found the defendant based on the fact that he made his phone calls in Attleboro. What initially centered them on him was his number showing up in the victim's call detail records within a short time prior to his death. And then getting that subscriber information, which they contacted the, I think, Warwick Police Department with, finding his name, using his picture to show to Mr. Phillips. There's no, they don't confront him at the interview with this 3 mile evidence. They confront him with, your girlfriend says you were there, and we know you called the victim shortly before the murder. They don't say, we know you were in 3 miles of this tower, to get him to sort of place himself in the room during that interview. So I would say that on that piece. Beyond that, regarding, I think we can probably be more productive with the instructions, unless the court has any questions on the CSLI. But I do think that viewing the instructions as a whole, I know the defendant highlighted several other errors, beyond the one that appeared in Silva. But notwithstanding, as Silva indicates, this court is familiar with this judge giving similar instructions, but as a whole, I don't think there's anything he's telling the jury to do that they shouldn't do or wouldn't have otherwise been required to do anyway. And so looked at as a whole, they accurately state the law. And to the extent that there were errors, they would not have given rise to a substantial likelihood of a miscarriage of justice. And if there are no questions on that second issue, I would rest simply on the arguments in the brief.
Okay, so you don't have anything else to submit. I raised an issue that we may not even have to address. You're all set with your arguments?
I guess I'm sorry. This kind of first time I'm finding myself in this situation. So if the court, I think I've said my piece on harmlessness, but if the court would like anything else as to that, or as to the good faith exception that we mentioned, I'd certainly be willing and.
No, we're not looking for anything else from you, sir. If you have
Okay,
something
sorry.
else to submit, we will hear you on that. But if you don't, it's fine. I'm not asking for anything extra.
Okay.
I just want to be clear for the record that you are not asking to submit anything extra.
I would ask for the opportunity to just submit something brief on the good faith piece of it.
Okay, so what I'm going to do is say that you have until Friday to submit your motion to do that. Okay, and what
Sure.
a brief statement on what you would say, and I'm going to give Attorney Fellows a chance to move to strike the submission. Okay.
Yep.
So you'll have a week after that. Okay, Attorney Fellows.
Yes, thank you, Your Honor.
Okay.
And I
very good.
apologize for interrupting earlier.
No, I appreciate having all the information right here, and we'll go from there.
Okay,
Okay, thank you, counsel.
thank you very much.
Okay.
Thank you.
That concludes today's hearings. Thank you.